kutupambanulia mawili matatu katika masuala haya, ambapo hivi sasa ni wakati wa kampeni, wanaangazia kinachoendelea, chuki zisiwe ni zenye kuenezwa. Atatuelezea kwa undani zaidi mikakati ambayo ameweka, lakini kabla ya hapo kuja kwenye mahojiano, mtazamaji, twende katika Mahakama Kuu ambapo wanamalizia ule uamuzi ambao ulitangazwa mapema hii leo jioni. Wacha tuweze kusikia kidogo kinachoendelea, alafu tutarudi tuendelee na mahojiano.
Compliments were not genuine if I make them afterwards. So I will just read a short ruling that we've crafted. The IEBC has orally applied for a stay of execution of the orders earlier given by the court. In short, the IEBC is concerned that if a stay is not granted, its intended appeal to the Court of Appeal will be rendered nugatory, since it would have begun to implement the order of mandamus given by the court. IEBC is concerned that if it expends public funds on the exercise of public participation ordered by the court, then it would not be prudent use of public resources. The IEBC also argues that a grant of stay makes it more likely that the appeal will be heard expeditiously by the Court of Appeal. The first, second, third, fifth, and sixth interested parties support the application for stay. The first interested party is concerned about the financial ramifications of the orders of the court, since it's of the view that the orders will affect its contract and the letter of credit that has been issued to it. The second interested party supported the application on the ground that a stay will forestall other parties approaching the court to gain similar orders with respect to the other 6 elections which were not involved in this particular suit. The third interested party asked for a time-limited stay of 7 days. Such a stay, counsel argued, was necessary to create time for the aggrieved parties to proceed to the Court of Appeal without the threat of committal hanging over their heads. The sixth interested party suggested that a stay will give the parties a chance to consider alternative dispute resolution in the hope that the parties can settle out of court, and hence avoiding an appeal. All the parties in favor of stay argued that the court's decision had far-reaching ramifications and broke new ground in constitutional interpretation, especially on the question of applicability of Article 10 to public procurement, Article 10 of the Constitution. It is only fair that the Court of Appeal gets a chance to consider the appeal from those decisions, they argued. The applicant was not so sure that the appeal raises any arguable grounds of appeal and suggested that the appeal is unlikely to succeed anyway. The applicant is also of the view that public interest militates against the grant of stay. It is concerned that the granting of stay here is akin to the court sitting in review of its own decision. The fourth interested party was of similar view. We have considered all the arguments made, and in view of the urgency of the case and the public interest involved, we decided to give an extempore ruling. A stay of execution is discretionary relief which the court can grant in appropriate cases. It is usually merited where a party can show that its appeal will be rendered nugatory if the stay is not granted. In this case, we have anxiously considered the application and came to the conclusion that a stay should not be granted for the following reasons. First, there is no clear showing that an appeal will be rendered nugatory if a stay is not granted. There is nothing, in our view, that the IEBC and the interested parties will be required to do which will defeat the appeal. On the issue of costs to the IEBC in obeying the court order, we should quickly say 2 things. First, while important, the cost for public participation cannot. So first, while the issue of costs is important, the cost for public participation cannot be a dispositive consideration on an issue that involves serious constitutional rights of Kenyan citizens. Second, if the stay is granted and the IEBC goes on to lose the appeal, the costs are likely to be aggravated rather than mitigated. Second, the nature of the case and the nature of reliefs granted is such that a grant of stay will have the effect of potentially nullifying the decision of the court and perpetuating the very violation complained against against the IEBC by making it more likely if IEBC is unsuccessful on appeal on merits, it would have succeeded in defeating the claims and rights of the applicant through the passage of time. Third, given the nature of this case and the profound public interest involved, it is imperative, in our view, that the IEBC begins compliance at the earliest opportunity. We do note, however, that the IEBC is in charge of its own calendar, and the court has not directed it on how to fashion its own program of public participation. Fourth, we are of the view that public interest militates against a grant of stay in this specific case, since, as the applicant argues, any time spent when the orders are held in abeyance will effete and weaken the quality of public participation ordered by the court and make it less likely that the IEBC will deliver free, fair, and credible presidential elections on the 8th of August 2017. Lastly, we are also of the view that in this particular case, the Court of Appeal is a more optimal forum for the filing of a formal application for stay. This is because that court will be aware of the extreme urgency of this case, as well as the dictates of its own docket vis-a-vis its own procedures in ensuring that the appeal is heard and determined expeditiously. For these reasons, while we find the intended appeal eminently arguable, we are unable to exercise the discretion to grant stay.
Since I am one of the cross appellants,
Yes.
and I did not hear a reference to my submission, I beg for a copy of that. I realize it's a bit too late to have it typed by Monday, but I believe I have a copy through your box. All these are, yes,
Mr. Harrison Kenyanchui, I made it clear that this is an extempore judgment, ruling, which meant we could not reference everything that the parties said. But I said that we considered all the submissions made by the parties.
I realize.
Yes. Very good. Yes.
My name is dated. It's almost nice. Harrison.
And with that, unless we have any other housekeeping matters?
Yes, there was one.
Yes.
Just one.
Yes, please. Yes. The judgment has been signed. We don't have enough copies to make this.
No, we'll photocopy.
You'll photocopy. So if you give you 2 copies, then you're in good place. One for those who are appealing and one for those who are not. Yes. Yes. Okay.
Thank you very much.
And with that, we shall rise. Thank you.
Wow.
Na mtazamaji, basi hicho ndicho kikao cha Mahakama Kuu ambacho kimekamilika hivi sasa kwa kuweka kwamba uamuzi ambao umetolewa hapo awali kwa tume ya IEBC kushurutishwa kurudi tena chini na kuanza ile shughuli, mchakato mzima kupeana zabuni ile ya uchapishaji wa karatasi za kura ya urais peke yake. Mtazamaji, itaanza upya, itatangazwa na watu watapeana maombi yao, alafu watakaa chini wasikize pia hisia za wananchi. Hili ni jambo ambalo limesisitizwa sana pale, manake ni kana kwamba walikiuka baadhi ya kanuni ambazo zipo kwenye katiba na hazikufuatwa vema walipopeana moja kwa moja zabuni ile kwa kampuni ya Al Ghurair kutoka jijini Dubai kule nchini UAE. Uamuzi umesalia papo hapo, na kama nilivyokuelezea kulikuwa kuna dalili hapo awali za kukata rufaa, lakini itakuwa ni wenye kuzifuatilia wakati kesi inapoendelea, manake upande wa mawakili wa tume ya IEBC wameomba wapewe ripoti nzima ni kiukamilifu, waweze kuitwali vema kabla ya kuja na uamuzi wao, hatua watakayoichukua. Mtazamaji, karibu sana. Sasa hivi tuendelee kwenye kipindi chetu chingine hiki ambacho tunajadili masuala ya uwiano na utangamano hapa nchini Kenya.